We're going to move on now at this point to our next portion, titled How Superfund Changed the World, Initial Response to a National Emergency and Its Evolution. Congressman John LaFaltz will be joining our group here, and I will not, obviously I've introduced him before, and we'll move on to our two additional participants. First of all, David Flynn. He's a partner at Phillips Lytle. Mr. Flynn is a practice team leader for the firm's energy, environment, nanotechnology practice teams. His practice is concentrated in the areas of environmental law and energy, focusing on regulatory compliance consultations and brownfield redevelopment. He's written extensively on environmental topics and was involved in the first successful conversion of a former industrial brownfield into a modern manufacturing facility in the whole state of New York. He advises clients on business development issues, regulatory issues around energy, state and federal authorities, hydropower, renewable energy, pilot agreements associated with solar and wind projects, and related advice with New York State real estate property law, tax law. He received a JD from the State University of New York at Buffalo Law School. He will be joined also by Paul Newreiter. He's president of the Krog Group. He earned his BS degree in civil and environmental engineering at Clarkson University and an MBA from Canisius College. He began his career with the Siegfried Construction Company in the 1970s, and in 1989 he joined Simonelli Construction when upon the acquisition of the Cowpower Siegfried Construction Management Group. As the senior vice president at Simonelli, he was involved in many of the Western New York's largest and most challenging projects. Mr. Newreiter has led Krog's efforts in brownfield redevelopment and has completed many brownfield and adaptive reuse projects. And I want to turn it now over to Greg Peterson, who will outline many of the activities here.
I'm back. Thank you for the participants early on. Man, that was a hoot. Thank you, Mary D., Judge Gerasi, Congressman LaFaltz. I get a feeling, Congressman LaFaltz, you and I could have talked for another 10 hours. I mean, there was just so much of his career is built in. But today we're talking about Superfund, and the actual title, How Superfund Changed the World, Initial Response to a National Emergency and Its Evolution. And some of the conversation was, I'm sure, on the Hill, was whether this was an overreaction, an overextension. And that conversation that you had to go before and talk to Justice Gorsuch's mother, which was a great little vignette. So the way we're going to fashion this next part of the program is David Flynn has a PowerPoint which he will present with regards to his practice and seeing how the Superfund legislation led to other reactions in Congress. And then Paul Newreiter, president of Krog, will have a conversation as a developer how the Superfund led to brownfield credits, which in fact have led to the initiation of much of what's gone on really in Western New York and throughout the country, but specifically in the Buffalo area dealing with brownfield tax credits, including some of the facilities here in Jamestown, New York. So that's how we're going to set that up. And then we're going to call all three of them up for a little panel discussion with Congressman LaFaltz, Paul, and David. So without any further ado, David, all yours. Oh, one quick thing, sorry. We will have available, Susan Murphy, our President and CEO, has 3x5 cards. So for those who are interested in a question, raise your hand. She'll come by, give you a card, and then we'll try to get those answered at the end of the program. Thank you.
Thank you, Greg. Good morning. I think it's still morning. It's good to see you all. Thank you for coming. First of all, I have to thank Congressman LaFaltz for creating my career. Graduating from law school in 1987, I was firmly focused on environmental law. And up prior to Superfund, environmental law really was not much of a career. There were land use issues, some zoning issues, a lot of things got sort of lumped together for environmental law. As a firm, we were handling Clean Water and Clean Air Act, things for big companies like Bethlehem Steel and Lackawanna. And those would come and go, and there'd be enforcement activity and permits and things like that. But what really kicked environmental law in the rear end was Superfund. And I can tell you, coming in the mid to late 80s, it was gangbusters. I mean, there were Superfund sites all over the country that were being identified, requiring investigation, remediation. And as we'll touch on in a moment, not just New York State, but a number of states had their own Superfunds, which were also kicking into gear and attracting attention and requiring companies to divulge information, investigate sites. And, excuse me, I can recall in the late 80s and early 90s, literally flying to a different city 3 or 4 days a week to either meet with the regulatory agency or what we call PRP groups, which are the companies that the regulators rounded up and said, you're responsible for this site, to figure out what to do, how to fund an investigation or a cleanup. So, Congressman, myself and my family, we thank you for your fine efforts in that regard. The Congressman did a great job on identifying sort of what teed up Superfund. And, of course, the whole response to a national emergency, and the national emergency was Love Canal. I'm not going to get into in any detail what the Congressman already touched on, and I think Greg Peterson as well identified some of the issues. But what was really fundamental in my view was what Love Canal was intended to be and what it ended up being. And the Congressman mentioned the fact that it was basically a defunct canal that somebody thought was a great repository for byproducts from manufacturing. And in this day and age, we look at that and say, how could they have done that? And what did they think would happen? But the mindset back in the 1970s and the 60s and the 50s and the 40s was that if you put it in the ground, it was gone and it wouldn't bother anybody. And it was not only an acceptable way to deal with materials and waste, but it was considered state of the art. And many would argue that what Hooker did with Love Canal was above and beyond. And yet we still had some significant issues. But Greg Peterson mentioned timing is everything, and I think it was important as well what the political and social setting was at the time that Love Canal hit. And in particular, if you looked at Western New York, again, that this happened in Western New York, we were dealing with such a profound change in the economy, and all of our large industries were under siege, and plants were closing down, and people were starting to envision a different path forward for the region. And in the middle of all of that, or maybe even more towards the beginning of all of that, you have this issue arise with the management of chemicals, chemical waste, and its impact on people. So I think it's important to really look at this in context, which we're talking about today. And why was it a triggering event? If you look at some of the historical information, you'll find that Love Canal was not so unique. There were other places. There was a so-called Valley of the Drums, which was, I think, in Kentucky or someplace like that, where there were hundreds of thousands of leaking drums piled in a field somewhere. That didn't trigger Superfund by itself. There were other locations, and I'm sure people would, from different parts of the country would say, we had it as bad or worse than the folks at Niagara Falls had with Love Canal. But why was Love Canal viewed as such a triggering event? And I think, again, some of it is the social context, some of it's the political leadership, both at the state and federal level, as it represented the region, and just a coming together of people and communities and aggressive citizen activists really force this pimple to a head, and it burst, and we got Superfund out of that. So what responses were actually considered by Congress? And we can touch on this with Congressman LaFalce in terms of dealing with this. But you heard that there was, some folks viewed this as not a national issue. This shouldn't be dealt with at the federal level. It should be pushed to the states. It should be pushed to the localities. I had not heard that, Congressman, that people were considering this as more of a local issue even than a state issue. But eventually, I think the conclusion was that it really required a federal response. And in a certain way, I think that has always been viewed as interesting and important in New York. And oftentimes, businesses in New York are concerned about their ability to compete in the world and in the economy because New York always seems to self-impose on itself a higher burden than the rest of the country does. And in some sense, having a national program which levels the playing field, theoretically at least, from Western New York to Southern California to Minnesota, theoretically the same program is out there, the same standards are out there, and in part, I think that was an important component of what led to finally there being a federal response and a federal statutory response to the problem. So what was the response to the national emergency? Well, as we've heard this morning, it was Superfund. Superfund is much easier to say than the Comprehensive Environmental Response Compensation and Liability Act. And Congressman, I hope you don't take credit for the title, but you may, or that may have come out of committee as well. And as we've talked about, it became law in 1980 in one of President Carter's final acts. Interesting component about it that a lot of people don't focus on when they think about Superfund is that it was actually had a tax component to it. And there was a tax imposed on feedstock chemicals and petroleum to fund the fund. Now that ability to collect that tax has lapsed and waxed and waned over the years. And right now, you may know better than me, Congressman, but I don't believe that it's authorized at the moment to collect the tax that is supposed to fund Superfund. And that becomes a fight every number of years and has been lapsed, I believe, for some time now. And the whole idea was that this new liability program under Superfund would, in addition to having companies address their contamination issues and disposal issues, it would create a fund to address orphan sites. And that, I think, is an important piece of this puzzle. So many sites that I've dealt with and that others have dealt with, they're orphan sites. There are companies that have been gone for years, if not decades, bankruptcies, whatever it might be, yet you have this area of contamination that needs to be addressed. Where do those dollars come from? Well, you could say it should just come from the general fund of the state or the federal government, but a specific decision was made to tax certain chemicals and certain feedstocks to the chemical industry in order to provide the funding to address these orphan sites. And of course, the liability scheme allows for the recovery of those costs, and with the idea that that fund would in some part be replenished. For a true orphan site, that replenishment oftentimes does not happen for the very reason that it's an orphan site and there is no one with assets to recover those costs from. But a number of sites are either a mix of orphans and viable companies or viable companies, and if the federal government spends money under the statute, they can collect those funds back, put it back into the fund, and redeploy them at other sites. Now, CERCLA, or Superfund, gave some very broad federal authority to respond to the release of hazardous or threatened release of hazardous substances. Some have argued over the years whether or not was this an overreaction in terms of the powers that were granted. There are provisions in Superfund that I think are sort of unique in federal law. For example, under Section 106 of Superfund, the EPA can issue a unilateral order directing you to go clean up a site. If you don't do that, they're entitled to collect a penalty of 3 times the cleanup that the government incurs in addressing that site. You have literally no due process rights at that point. You can either do it or not do it at your peril. Now, if you do it and undertake the cleanup under 106, and you weren't the party that's liable for it, the statute does take care of you in a certain sense, and that is you can then make a claim against the fund I was just mentioning to get your money back. I'm not sure that that's happened more than a handful of times that I'm aware of in the history of Superfund. So it's an unusual statute in that your right to position yourself, to advocate for yourself, and to have due process in certain situations can be pushed to the back of the train, again, in the sense that we're trying to protect human health and the environment, and that takes precedence. There were a lot of issues and concerns with that. So this whole construct of this new broad federal authority was I think, quite unique at the time, particularly in the environmental arena. And the statute itself gives you very limited defenses to liability. It's a strict liability statute. An interesting story, when Love Canal was just hitting and the state and the federal government, they were all scrambling, trying to find out where are the other Love Canals. We know they're out there, we just don't know where. So they sent out questionnaires to businesses, to industry, and they said, you've got to tell us, what did you generate in terms of waste or byproduct? Where did it go for disposal, and who took it there? And in a sense of being naive at the time, and this again is really before anyone understood what the Superfund statute meant, these folks believing that, well, everything we did was above board in accordance with law, there certainly can't be a retroactive liability statute coming down the pipe. They were very forthcoming, including some of our clients, much to their chagrin these days. And they said, this is what we generated down to the pound. It could be 3,942 tons we sent to this location and that location. And lo and behold, those answers and those survey responses come up time and time again, even today, in terms of saying, you sent material to this site, it needs to be cleaned up. And I'll tell you, if those surveys go out today, you get a bunch of yes/no answers and not a lot of detail now that the people understand how the statute works. So the very limited defenses to liability really structure Superfund as a strict liability law, and if it's your material and it's here, chances are very strong that you're a liable party. So retroactive strict joint and several liability scheme. I'm no legal scholar, and as you can tell, my practice has been very focused over the years in the environmental arena, but there aren't a lot of those statutes out there. That I do remember from law school, that there aren't a lot of retroactive strict joint and several liability statutes out there. Purposefully. I mean, I understand the need for it and the drive behind it to protect human health and the environment, but in the early to mid 80s, there were epic constitutional law cases brought regarding the constitutionality of CERCLA because of that. It was quite intriguing to see the courts deal with these issues of Company X saying, what I did was I had a permit to do it, I was inspected, everybody told me I was doing a great job, all the regulators, and now you're telling me what I did was wrong 20, 30 years later, and I have to go back and fix it. And there were a lot of concerns about that, but Superfund managed to navigate those rocky waters and stay together through these constitutional issues as they were resolved. But in large measure, it remained intact, and to this day, every once in a while you'll get a neophyte environmental lawyer or somebody who thinks they're an environmental lawyer who will, in some sort of a litigation, try and raise the constitutionality issues again of Superfund. But I think that's the good application of the dead and buried rule on that one. So what are some of the key underpinnings of the Superfund statute? Well, the recovery of remedial costs. one of the big punchlines for Superfund is the polluter pays. So whether the polluter did it intentionally, unintentionally, doesn't matter. The whole idea is that the polluter should pay. Now, that oftentimes raises issues of, okay, company X generated this material and disposed of it, perhaps properly or improperly, but should just that company and its shareholders incur these costs, or should it be more broad? Should we as society who benefited from these products that were manufactured and created, and the waste streams now create environmental problems, should we all bear some piece of that? But where it's hung together to this point is that the polluter pays, the PRP pays. Now, how do you make that fair, quote unquote, in the context of strict joint and several liability? Well, the key component is that the statute provides a right to contribution. So under the statute, if the federal or state government come to you under CERCLA and say, we have evidence that you disposed of hazardous substances or waste here, we want you to clean that up. You can say, well, there's 15 other companies that put material there. As it relates to the government, their position can be, and sometimes is, we only need one person, and you are required to clean the whole site up. You can collect or try to collect from anybody else you think is responsible, because the statute provides rights of contribution, but they don't have the obligation to bring all of the parties that may have contributed to the contamination into the party, into the litigation, and they don't take a hit if, for example, someone is gone or bankrupt, or there's what we call an orphan share at the site. The government doesn't have to take that hit. Whoever gets identified as a PRP, whether it's 1 or 5 or however many, they have to absorb that cost. So what if there is no polluter to pay, the so-called orphan sites? That's where the fund, again, kicks in and can provide necessary funding for the cleanup, which occasionally some of it can be recovered, but eventually leads to the sort of the drawdown on the Superfund itself, requiring the need to raise funds somewhere else, or as we hear from time to time, Superfund is running out of money, they're going to have to stop work at sites, whatever it might be, and that usually leads to some action to replenish it. Similarly, on the state side, the state has a Superfund. It certainly is smaller in dollars than the federal, but you may recall under not this most recent budget, but prior year budget in the state, they've agreed to put $100 million a year in for 3 years to the state Superfund so that it can continue to have funding to address sites and respond to contamination conditions. Under CERCLA, there's a fairly broad range of parties that can be liable. And again, there's no fault here necessarily. There can be fault, but there doesn't need to be fault. So the current owner of a property, putting aside all appropriate inquiry and some very sort of nuanced and detailed due diligence issues that can sometimes act as a defense, but generally the current owner of the property, whether they contributed to the contamination or not, is a liable party. The company that generated the waste or the hazardous substances that were disposed of through their manufacturing process, whatever it might be, they are a liable party. The entity that hauled the waste, the haulers, the waste haulers, that took it from manufacturing plant X and put it in landfill Y, they are a liable party as well. Some issues came up probably in the early to mid-90s in terms of what did we really intend with Superfund here, and what are some of the unintended consequences of it. So we get into things like lender liability. So I've worked with several secured lenders over the years, and in a couple of instances they've gotten themselves into trouble under Superfund in terms of how involved they get with their borrower. So when your borrower everything's humming along nicely, they're making all of their payments, and there's no issues. Rarely, if ever, does it become an issue. What happens is if there's a bankruptcy or some sort of a workout and the bank would start to get involved in the day-to-day operations of the business. So there would be a lockbox. Before significant expenses were incurred, the bank needed to sign off on that. Management needed to check with the bank if they could arrange for the hauling and disposal of waste this week. The banks and lenders started to get more and more entrenched, as they had in the past, in order to protect their position and their collateral. When the company, their borrower, eventually went bankrupt, the government and others turned to them and said, you were basically the de facto operator of this facility because you controlled the purse strings and did some other things. And a number of secured lenders were found liable on that. So that started to have a chilling effect with lenders, and in particular industries and business sectors where lenders were getting very concerned. So that led to the creation of what we call the lender liability rules, which laid out how far a lender could go and be protected under the statute, i.e. not worry about becoming liable. And if they went past that stage, they knew they were getting into trouble. So one of the first unintended consequences, I believe, of the Superfund statute. Another issue that came out was how clean is clean, and Paul will talk about this in a little bit. But originally, Superfund, the goal of the Superfund statute, and I think it's still there in the statute, the goal is to restore a site to a pre-release condition. So that means this piece of property, our goal is to clean up this property so that it is as if nothing had ever been spilled or disposed of here. That can be extraordinarily expensive, and you can ask yourself, is that ultimately necessary to protect human health and the environment? And honestly, in implementation, Superfund has rarely, in my experience, required that. But it was, some may say, is somewhat of a utopian view to sort of erase the whole presence of chemicals and hazardous substances from a piece of property. But is that the highest and best use of not just Superfund funds, but company, people, private sector funds, to spend $100 million instead of $10 million to remediate a site to a pre-release condition when you can remediate it to a point where it's safe for human health and the environment for significantly less funds. So that brought in a whole issue of value judgments in terms of how clean is clean and what's the proper deployment of scarce resources to address so many sites that exist across and around the country. And it allowed the whole concept of cost effectiveness to come into the process. And as I'll chat about and Paul will bring up later, that's a key component to the whole Brownfield program in terms of cost effectiveness and remedial goals that meet certainly health and safety standards, but reflect the future use of the property. And how does that future use play a role in the remedy selection process? As I mentioned, under Superfund, it really has no place in that process. By regulation and by guidance, EPA and the state DEC have woven that into their Superfund process, but where that really takes hold is in the Brownfield program, which we'll be discussing shortly. So the question I think that's fair to ask is, how has Superfund worked? And I'm sure the Congressman has some views, perhaps pro and con as well, and at least as to discrete portions of it. I think if you look at it as a whole, it's been very positive in the sense that you don't hear often about new love canals. We seem to have a good handle on where materials are. There's been an effort to address worst first, which has been underway for a number of years. There certainly still are a number of sites out there, and every once in a while one will pop up that you, at this point in time, you're surprised that something that's that bad is just being identified now. But certainly the whole program, I think, has been effective, not only in cleaning up sites, but in generally pushing companies to better manage on a prospective basis how they manage their waste materials going forward. You can have carrots hanging out there, but the prospect of the Superfund stick, I think, has been very significant in changing corporate culture and decision making in terms of either minimizing the quantity of waste, looking for ways to limit its toxicity, if you can use compound X versus compound Y because it's less toxic. A lot of industry is moving in that direction. And then also the proper maintenance and disposal practices going forward so that you're not creating new Superfund sites that you're going to hear about 5 or 10 years down the road. So while many federal Superfund sites have been remediated in the last 25 years, since CERCLA really kicked in, there still are many to go. There's thousands of federal Superfund sites that are still out there in various phases of either investigation or some in the remedial phase, and including a number of state Superfund sites, whether it be New York or New Jersey or other states that have their own program. So there are still a large number of sites out there. The big, open, and notorious ones, as I said, don't seem to come up all that often anymore, and it's become somewhat a routine in terms of how these sites are dealt with. But every once in a while, you do get there is a new site that comes up unexpectedly. And there are smaller sites that are being addressed, and some of these sites are actually starting to be addressed under the Brownfield program, which I think it has many benefits. The so-called state mini Superfunds are interesting in my book because they really get into the issue that the congressman was talking about. Is this a state or a federal issue? The federal statute suggests a federal response and a federal level of interest, but only certain sites are subject to the federal Superfund. So for a site to be subject to the federal Superfund, there's a scoring system that the agency utilizes. It's the hazard ranking system. And they go through and they score up a site based on what the chemical is it in soil, is it in groundwater, is the groundwater used for drinking water, and so forth. And if a site score does not get high enough, it doesn't get on the federal Superfund, which means generally that federal Superfund dollars aren't available. And in many instances, that's where the state Superfund programs slide in. They take those sites that don't qualify for the federal program, don't get on what's called the National Priorities List, which is a ranking of all Superfund sites that rank or score high enough. But there are probably at least as many, if not more, non-ranked sites that need to be addressed, and many of those are being addressed under these state programs. And these state programs, in many instances, mimic the federal program in the sense of the general liability scheme. There certainly can be differences from one to the other, but they really are, in large measure, they have two things. They have that strict joint and several liability scheme, and most of them have a fund component to them to address the orphan sites, or the sites where there's no viable party that can incur the remediation sites. And as I said at the beginning, if you were to ask a number of folks, particularly in the industrial sector, how Superfund has worked, they would say very well for the lawyers and the consultants and the remedial folks, not necessarily for them. What are some of the negatives to the Superfund statute, at least as I've experienced it over the last 25 years? Certainly the liability scheme and the potential remedial costs impacted the redevelopment and reuse of properties. We can all identify societally many reasons why urban centers have decayed. Oftentimes people talk about the apple rotting and the cores rotting. I think a key component to that has been the liability scheme under Superfund. People have really been scared off from big old industrial properties, at least up until the Brownfield programs took place, because you didn't know what your liability would be as the owner. You didn't know what the cleanup was going to be. You didn't know what it would cost you. And unless you had a very unique property, oftentimes the value of the remediated property was less than the cost to clean it up. So why are you going to acquire that piece of property? Why are you going to try and reuse it? It's a lot easier to go, out of town and get a clean piece of suburban property that you don't have to worry about, even if you have to pay more per acre on the front end, because at least you know what you're paying and you're not getting into a never-ending battle with a regulator and some potentially horrific costs. And this led to a number of parcels being upside down. You think about the Buffalo area, the Bethlehem Steel Complex, the Allied Chemical Complex, the Republic Steel Complex, where Solar City is now going in. All of those have laid fallow for years and years, and it's in large part because of the contamination issues. And how can you get around those or address them in a way that is still cost effective for you to do something with those properties? And where are these sites concentrated? Well, they're primarily in urban areas. There certainly are sites in non-urban areas, but that's where you find the clustering. So you almost have the, you talk about critical mass, but it's almost the negative critical mass. So if you looked at downtown Buffalo, in South Buffalo 6 or 8 or 10 years ago, I mean, you had these huge tracts of land that nobody would deal with, hundreds, up to, I would say, a couple thousand to 3,000 acres if you added them all together in a fairly concentrated area that nobody wanted to touch. Well, guess what happens with everything around them when those areas are just left to fall and disintegrate and sit there unremediated? The neighborhoods around them start to deteriorate. All sorts of negative things happen. So you have to figure out a way to deal with that and the impact that's had on older urban areas. But it also contributes, I think, to sprawl, because if you're doing something and you don't want to take the risk in the urban area, where do you go? You go out to the suburbs or to a rural area where you don't have those issues. So in addition to some of the classic sprawl issues that the Buffalo or Western New York area has encountered, I think certainly Superfund has played a role in pushing some of that, and I think by any measure, Western New York is sort of world class when it comes to sprawl issues over the last 20 or 30 years. We haven't, the population, if anything, has gone down, yet the footprint has grown and grown and grown. And I think in part that was one of the unintended consequences of Superfund. Well, what are why has this happened? Well, I touched on it before, how clean is clean. Unrealistic remedies, I think, are partly to blame. Early in Superfund, it was we're going to dig all of this stuff up and haul it somewhere else. That's incredibly expensive to do that. Are there ways to manage the risk in a way that protects human health and the environment, yet isn't so depleting to the overall process that you can find a way or figure a way to redevelop a site in a way that's cost effective and makes sense? And the slow pace. Superfund has been around for 25 years, 30 years, but you look at the pace of cleanup, and oftentimes people are left wondering, why does it take so long to address a site, whether it's a federal Superfund site or a state Superfund site? How can we pick up that pace? Because once we can get these sites remediated, then maybe we can do something with it. Yet we have Bethlehem Steel that's been sitting out there since the late 80s, early 90s with only some sporadic fixes to it. And even as recently as 2 or 3 weeks ago, DEC was announcing they finally selected a remedy for a significant piece of the Bethlehem Steel site. It's been down for 20 years, and they're just getting to that point now. So the slow pace is there. And then at the end of the day, there's always, in my practice area, in the Superfund area, the lack of finality. So you can clean up a site, the agency can sign off on it, you can get a release of liability from the state and their program, but guess what? If 5 years from now somebody finds a pool of PCBs underneath that site that nobody knew or suspected that was going to be there, you're going to be back on the hook for it. So the finality issue is also something that that has begged to be addressed, and in part that's a big issue with the Brownfield program as well. So how are we dealing with what I'll call the unintended consequences of Superfund? Well, relatively soon after the passage of Superfund, I think 5 or 6 years, there was the Superfund Amendments and Reauthorization Act. Everybody recognized that there needed to be some tweaks to Superfund. And there were good and bad changes. The congressman described the sausage-making process of committees working together to create this legislation. But one of the good things was this statutory right of contribution. Up till these amendments to Superfund, the right of contribution was really, it was common law. It was a common law right of contribution that was installed by judges in federal court that just looked at it as a fundamental fairness issue, particularly with strict joint and several liability, but that was codified statutorily with the Sarah amendments. So in my book, that's an example of a positive change. Perhaps a negative side was they decided that there should be now damages collected for natural resource damages that really didn't exist, at least in practice, under the original Superfund statute. But today, and this often comes up in contaminated sediment sites, the federal government and the state government, as trustees for natural resources, can collect damages for the degradation to the environment from that site. So if there's been a fish advisory in a river for the last 30 years, they can attempt to quantify that and say that's a $30 million loss for the community. And they can come after those same PRPs that are responsible for the cleanup for those damages. They can, if there's been additional costs to handle dredge materials, to keep a port open because of the contamination, they can collect for that. So that's, in my view, an example of a change that wasn't particularly helpful in terms of moving Superfund along. But in my book, the biggest positive response to Superfund have been the Brownfield Initiatives at both the federal and the state levels. Now, these provide now a liability release once you complete your work to the agency's satisfaction. That's a positive and something that doesn't exist under the Superfund statute. Risk-based remedies. When I started talking about risk assessments and considering risk in the remedy decision-making process, that was viewed as hokey science. It's just the polluters trying to figure out a way to leave more crap behind and spend less money on a cleanup. But it really has become much more understood and mainstreamed in concept, to the point now where the agencies actually have established different cleanup levels depending on the use of the property going forward. So if you have a piece of contaminated property and your view or vision for that is to put housing on it, well, there's a cleanup level for the contaminants that's based on that exposure. If, however, you want to put a factory on that or a commercial building, a different exposure scenario, they're different and almost always less conservative cleanup values for those constituents. They're still protective, but the exposure concern is much different for a factory worker in a factory building on a piece of property versus a homeowner with small children playing in the backyard. And the ability to adjust and establish cleanup levels that are based on reasonable use scenarios is the underpinning of these brownfield programs, and I think it's been a real positive. And then finally are the incentives for the remediation and redevelopment. I talked before about how oftentimes properties are upside down, and even if you look at a property and apply a risk-based cleanup approach to it, unless you're in Manhattan or some other areas where the property values are so high, oftentimes those properties would still be upside down, in that you would spend more money to clean it up than the raw land itself is actually worth. So, at least and primarily at the state level and here in New York, we've implemented incentives which provide refundable tax credits for cleanup costs and redevelopment costs. And the whole goal there ultimately is to level the playing field and to make it as reasonable and positive from a business perspective to redevelop an existing property that's contaminated with a fresh cornfield site in the suburbs. And that's ultimately been the goal, is to level the field so that urban sites are on the same playing level as greenfield sites elsewhere. And as Greg mentioned, the benefits we're seeing from that are significant, particularly in Western New York, where you're seeing more infill development within the urban areas. You're seeing it in Jamestown. You're seeing it certainly up in Buffalo. And I joke with my colleagues that it's rare now to have a significant development project in the city of Buffalo that is not in the state brownfield program. Just about every project of any size goes through that project, and we're seeing now sort of the infill into the urban core with both housing and commercial and industrial reuse and redevelopment. So those and some other regulatory reforms have been, I think, key to reversing some of the unintended consequences of a very good statute, and allowing a good statute to continue to do its good work, but to mitigate against some of its unintended consequences. With that, I'd like to ask Paul Newreiter from Krog to step up. Paul is on the front line, and people like Paul in the development community are on the front line with these issues every day, and trying to make sound business decisions about where to develop or redevelop. And Paul and his crew at Krog have done a lot of work in this area, and I think have sort of figured out where their comfort levels are. So, Paul?
Figure out how to move on to the next slide, or is it as simple as? I'll let the technical expert do that.
Let's see. Is that one yours?
Nope. Looks like this.
That one.
There you go.
There we go.
Excellent, thank you. Well, thank you, David, and good morning, everyone. I'm humbled to be here with all of these attorneys, congressmen, judges. They should never let an engineer get into such a group of scholarly people who are going to challenge my knowledge and intelligence, I'm sure. But thank you very much for inviting me here today. I'll start out with a little bit of a commercial about us, perhaps, if you'll indulge me for a moment. As David said, we've used the Brownfield Cleanup Program extensively since it was initiated in 2005. And here we're shifting gears from the federal to the state level, really. And what we've done, I'm told that if not the most prolific today, we were one of the most prolific brownfield redevelopers in New York State. We happen to have completed the first project under the BCP program in 2005. David, was that the first project that you were involved with as well? Okay. So we did the Certainty plant, a 277,000 square foot new manufacturing facility to make plastic architectural products in the Buffalo area on a site that was the former Hanna furnace site related to Bethlehem Steel. But we've done all kinds of projects. We've done hospitality facilities. We've done medical office buildings. We've done industrial and manufacturing projects. And most of those projects would not have occurred, certainly would not have occurred on formerly brownfield, formerly industrial sites had it not been for the brownfield cleanup program. Couple of images there. The one in the upper left corner you'll probably recognize if you're from here in Jamestown. It's the Riverwalk Medical Center, one of the earlier BCP sites that we completed. The one on the upper right is actually Welded Tube USA. They're a pipe manufacturer. That's on the Bethlehem site that David mentioned. We've built on the Republic Steel site and others as well. We've got a few projects on the drawing board. A couple of years ago, Senator Schumer invited me to a roundtable discussion about brownfield redevelopment, and at the time I said, you know, one of the things that's lacking, so many times we talk about brownfields as vacant former industrial sites, and a lot of times the buildings that were on those sites are gone and there's a field there. It might have concrete underground or other things underground that you can't see, as well as those contaminants. But one of the things that wasn't happening is development of vertical brownfields. So one of the projects that we're involved with right now in Buffalo is the redevelopment of the former Trico plant number 1. It's a roughly 600,000 square foot building today. It was admitted into the Brownfield Cleanup Program in 2013. It's got a complex financing structure which involves historic tax credit. The building is on the National Register. So we're using state and federal historic tax credits coupled with the brownfield tax credit to develop that building into an extended stay hotel, a residential property, as well as a commercial property, so a mixed-use adaptive reuse. We're going to talk in a minute about a case study on a former refinery site that we tackled. I call these legacy sites. David, what did you call them? You had a name for them. That was, yeah, orphan sites, right? Well, it wasn't exactly an orphan. It had an adopted parent, at least. But we're also working, and actually David is working with us on another refinery site in Buffalo that we're working closely with the successor to the entity that created the problem on that site on Elk Street. It's a 70-acre site. It was a refinery. It's heavily impacted with petroleum product. And then back to the Bethlehem Steel location, we're working on a very unique project there involving a very high-tech vertical farm, and we're looking to break ground on that next year. So as a developer, you know, what do we look at? Well, many of the things that we look at are the same, whether it's a brownfield site or not. You know, we look at transportation access. Our users often are interested in the available labor pool. We look at the availability of existing utilities, especially proximity to low-cost power, which has been driving a lot of the development at Bethlehem, the availability of NYPA power allocation. We look at the geotechnical soil conditions, not only the environmental conditions, but the structural conditions. And needless to say, we look at the land cost as well. But then when we get to a brownfield site, we've got other things to consider. We look at how is the soil and groundwater impacted. We look at whether or not there are structures that need to be removed above or below grade and the cost of such removals. And then we take into account the long-term impact on that redevelopment. What are we going to have to do even after the cleanup is complete to continue to keep the property in compliance with the environmental laws? Do we have to continue pumping operations? Is there maintenance of cover systems and so forth? How are we going to comply with the site management plan that dictates how we're going to work on that site into perpetuity? It's defined by an environmental easement and a prescribed set of procedures, and we need to understand how that's going to impact the long-term cost of owning that property. But as David mentioned, there's some incentives that come with being in the Brownfield Cleanup Program. One of the advantages is land availability. Many of the largest tracts of land in urban areas are former sites, former industrial sites. So when we look at wanting to locate in these urban areas, we're almost inevitably tied into the need for a remediation project and the incentive that comes with working in the Brownfield program. Land costs are typically lower. Sometimes they're negative. The program provides a refundable tax credit to incentivize the development. And it also helps us leverage other incentives. I mentioned the TRICO project and the use of historic and state and federal historic tax credits. But we've also been able to work with local agencies, the IDAs, for example, who have some specialty pilot programs that help incentivize redevelopment of brownfield sites. National Grid has been very, very receptive to redevelopment of brownfield sites. They have a specific program to help incentivize those redevelopments. But there's still some challenges. One of the problems that we encounter, obviously, is the environmental condition. I'll talk about that in the case study that I'm going to show you in just a moment. But probably the biggest problem we've had with redevelopment in attracting users is the stigma. I can't tell you how many times we have tried to pitch the redevelopment of a brownfield site to somebody who's, what I'll say, is uninitiated to the process. And there's still, I would say, the majority of users that will look for the clean site. They'll say, well, has there been an environmental phase 1 assessment performed? And we'll say, sure, there has. Phase 1, phase 2, an extensive environmental investigation. But they don't often get past that phase 1, and they say, gee, you know, there was something in the ground, I think we better look elsewhere. They're nervous about that. So it takes some education on for a user to get comfortable with being on that site. There's always been some risk of uncertainty. There's two kinds of uncertainty that really we encounter. One has been the regulatory uncertainty. You know, up until 2015, the life of the New York State Brownfield Cleanup Program was short. It was expiring at the end of 2015. Not until the budget that year did it get extended, and thankfully it was extended for 10 more years. So some of that regulatory uncertainty has gone away. There's some uncertainty about the level of cleanup required. When you go into a project, there's a lot of work to be done, both to investigate and determine what that remediation procedure will be, and also to get the DEC to understand and agree with the approach to that cleanup. The other kind of uncertainty, which has been more difficult for us to deal with, frankly, is from the Department of Tax and Finance. Inevitably, on a BCP cleanup project, a redevelopment project, where those tax credits come into play, the state is extremely slow. I should probably ask, is anybody here from the state? Okay, good. I can keep going. I should have used my pseudonym instead of my real name. So when we do these projects, inevitably we find that we're facing an audit, and the audits are excruciatingly slow. When we file, we don't anticipate even being notified of audit for months after our tax filings, and then we go through multiple rounds of evidence that we did in fact incur the costs we claim we've incurred. It really is very difficult when you rely on those tax credits to incentivize that redevelopment and then realize that it can take years to realize that refund. That's one of the challenges. There's always physical constraints. We touched on those a little bit, and you face those in really any redevelopment. So the economic incentives. Under the current version of the program in 2015, the site preparation tax credit is approximately 25%. So any of the remediation costs that are associated with a project, the refundable tax credit is 25% of those costs. Then there's a tangible tax credit. So the new improvements that are made on the property, buildings, capital equipment if it's permanently affixed to the site, site improvements, those see a baseline tax credit of 10% of their costs. I think there's a typo there. End zone is typically a 2% increase over that tangible. If the property's in a brownfield opportunity area, there's one here in Jamestown. Many municipalities now have brownfield opportunity areas. Dunkirk is in the process. South Buffalo has one. There's many around the state. That also enhances the tangible tax credit. A higher level of cleanup will enhance the tangible tax credit as well. Those are capped. They're capped at 24% on the tangible. They're also capped based on the cost of the remediation, so that projects that have reasonably manageable remediation costs but very large tangible improvements don't have a runaway tax credit. I think there was some big concerns in the New York City area where perhaps small parcels that might have had a dry cleaner or something like that on them might then invest $100 million on a mid or a high-rise building and see an unlimited tax credit. That's been resolved by putting these caps in place. And the caps are either 3 times the cost of the remediation if the project is a non-manufacturing project, or 6 times the cost of remediation if it is a manufacturing project. And there's also a dollar amount capping those as well. One of the things we like about the program is it has a 10-year life subsequent to the completion of the cleanup. There's the end of the work, you receive a certificate of completion which verifies that you did what you said you were going to do to that site. And from there forward, you're eligible for that tangible tax credit for 10 more years, again, subject to the cap. The state issues a limited liability release. We also like that. I think the key word there is limited. There are reopeners on that liability release. If you clean it up to a certain level and the law changes in the future, you may have to go back and do some more work. But it is an important liability release. And one of the things that changed in the new program that we were always unhappy about, because we always saw bills coming in year and a half later from the DEC, is they've eliminated the oversight costs. So there's a site. That's Olean, New York, probably around, I'd guess maybe 1920, 1930s. That's the Felmont Oil site. It's a refinery. It's 58 acres. We acquired that site about 3 years ago from ExxonMobil, who was the successor to Felmont. And this is a partial image. So we had a vision of taking that 58 acres and cleaning it up and creating a destination retail and hotel location. It's a great site. Lots of power availability, all those things that I talk about when we look at any site. Access to the highway, proximity to the city center in Olean. It was a great location, aside from the fact that it used to look like that. So let me walk you through how this one played out. As David mentioned, it takes a long time for some of these projects. I call this a legacy project because ExxonMobil had the responsibility for that cleanup. We first met the folks from Exxon in 2007, in the spring of 2007, and we closed on this deal in 2013. I think there were some fits and starts in terms of their progress. There was a lot of environmental investigation that was going on. But things really started to take off in 2013. It's a 58-acre parcel, former refinery site. It was actually in the Brownfield cleanup program and extensive impacts. They picked us to be the purchaser of the property. We formed a single-purpose entity, which we typically do for any of these sites. We formed this entity called Olean Gateway. We had to reapply to the program because Exxon was in as a participant and we went in as a volunteer. So both participants and volunteers can't be on that BCP application together. So we reapplied, got into the program post-2008. We then completed even more investigation. Exxon had done hundreds and hundreds of test wells. We wanted to do our own, so we did our own due diligence, enhanced what they had investigated, and we developed a plan for that remediation that the DEC was comfortable with. One of the key things in these legacy deals, though, is the buyer's willingness to indemnify the seller from liability going forward. That's the whole reason that somebody like Exxon wants a developer like us to come in. They're looking to divest of their property and walk away from the liability to the extent that they can. So they look for us to indemnify them from that, protect them from that liability. And for the most part, on a site like Olean, we do. We provide that indemnity. We provide them some performance assurances as well. Those take a number of different approaches. One is just relying on our experience on these sites and proven track record. Sometimes we provide performance and payment bonds. In terms of the long-term protections, we've provided a letter of credit to secure the funding for the post-completion operation and maintenance of ongoing remediation facilities. So what did we have to do there? So we took out 150,000 lineal feet of pipe. That's like 28 miles. It's like taking out the pipe from here to Dunkirk. It was impacted with petroleum. We pulled it out by piece. We cleaned it, disposed of the product. So we treated soils. Some of those soils we excavated and treated ex situ, meaning they were on site and aerated and seeded. Other areas we dug out hot spots, which were usually heavy metal contaminants. Those were hauled away and disposed of off-site. We treated lead soils in place with, by amending the soils. There's an ongoing pump and treat operation. We're doing soil vapor extraction. You name it, we've done it there. There's a couple of images of what that site looked like while we were working. I think the thing that was most intriguing to Exxon, though, is we came to them with a redevelopment plan. And there were three distinct parcels. The one that I showed you in that earlier image was parcel number 1 predominantly, and that's where the retail and hotel component is targeted. The other two parcels, which are set back from the road a bit, we've actually sold to an entity called Solian, which is a solar and wind developer, and they've developed a 6-megawatt solar farm on those properties. The image looks better on the screen than it does on the laptop here, but that gives you an indication of how that site will eventually look with the solar in the back portion and the retail and hotel component in the lower part of the slide. So as David mentioned, a lot of these sites are upside down. This site was upside down to the tune of almost $15 million. So the land value was when you take into account the remediation cost, was negative $15 million. We take advantage of the brownfield tax credit when we take on these properties. It helps us reduce the remediation costs. It also provides us some contingency buffer. The Cattaraugus County IDA, as I mentioned, have an aggressive pilot program. They developed a special pilot program specifically for brownfield sites that offers a 10-year 100% abatement on the improvement, on the increased assessment, and then tailing off over the last 5 years. So that's helped us incentivize some of the redevelopment there as well. The city had landed a Restore New York grant a number of years ago that helped with the demolition and actually helped construct a new city street. We're building it and dedicating it to the city. We're completing that this spring. And then National Grid's Brownfield grant assisted as well. So the BCP program helped leverage some of those other incentives. So just to recap a little bit from my perspective on what's working and what isn't, I don't think we would have seen the number of redeveloped brownfield sites throughout Western New York. And Western New York has been the predominant user of the state program. For some reason, much more so, and perhaps because of the Superfund and the notoriety of Love Canal. I think perhaps we're just more conscious of this in Western New York. It may be because of DEC Region 9's emphasis on the program, but as David said, there have been many projects in Buffalo and throughout Western New York that have occurred strictly because the Brownfield Cleanup Program is in place. It's been a key to downtown redevelopment, and it will continue to be, I suspect, over the next few years. One of the things that we've also found is that lenders in New York are now comfortable with the program. There is a level of reliability both in what has to be done to the site and the reliability of that refundable tax credit, despite the fact that it takes a long time to get. Eventually you get there, and lenders are willing to lend against those eventual returns so we can monetize those tax credits in advance. What could be better? Well, it does take a heck of a long time to make these happen. Our TRICO project, just to get through one step of approval, has taken 9 months of review by the DEC. So it takes a long time to get through this. There's a lot of investigation. There's a lot of preparation, report writing. There's reviews by the DEC. And frankly, I think they're probably understaffed for the amount of work that they're facing. There's also oversight and peer review by the Department of Health, and that all takes a lot of time. There's also community involvement. There's prescribed review periods. Community gets a chance to review the proposed remediation method, and there's a 45-day review period there. So there's a lot of time that goes into it. It'd be great if we could make these happen faster, because unfortunately, a lot of the users that come to us don't have a 4-year planning horizon. They have maybe a 1-year planning horizon. And it's hard to move these projects forward if you don't know that you've got a user ready to go. I mentioned the tax delays, so I won't reiterate that. The other thing that's somewhat disappointing to us is that these New York State tax credits, these New York State refundable tax credits, are then federally fundable. So it really dilutes what the state's doing to the tune of 35 or 40% for most of the developments. The good news, I think, is that there has been a push. I don't know if it'll get traction, but there has been a push to try and take this kind of a program that we have in New York State, which I think is pretty unique, at least in the Northeast. I'm not aware of any other states that have a program as aggressive as New York's to do this kind of redevelopment, and provide a similar federal level program. One of our associates that we work closely with was scheduled to be at the White House and try and lobby for such a federal program later this month. So we're keeping our fingers crossed and hoping that perhaps that'll occur. So just to wrap up, you probably wonder why I have this picture of this beautiful waterfront hotel. That is in fact a Brownfield Cleanup Program site. That's a hotel we built in Watkins Glen. It's on the site of a former asphalt plant and a dry cleaner, as a matter of fact. So it had petroleum product as well as trichloroethylene in the soil and groundwater. That hotel was about an $18 million project for us. It saw roughly a $2 million BCP refundable tax credit. And that site probably wouldn't have been developed without that. What I think is most important here, because every time I tell this story at dinner with one of my closest friends who has a different view of how incentives to developers are deemed, he always likes to use the word corporate welfare. I like to remind him that this project then generated, Schuyler County did an analysis of the tax revenues that came off of this project. Since we opened in 2008, it's generated more than $10 million of new tax revenue just from sales tax, bed tax, and property taxes, not taking into account any income tax either from our entity or our employees, no indirect or induced impacts either. So $10 million in a little less than 10 years. And we're doing the same thing right now up in the Thousand Islands with our hotel there, and they're seeing similar benefits there. So while the state spent a couple $1 million, it didn't take long for that couple $1 million to come back and multiply. So, and that's why these programs work and why they should continue to work. So thank you. Look forward to further discussion.
Congressman, Paul, if you could join us up front here, I'd appreciate it. Greg, have you assembled any questions?
Anybody have any specific questions? If not, I've got a few. We'll get you mic'd up. David, why don't you join? Just join. Football coming up soon. Football, Bills, stories. Denny Lynch is already trying to figure out how you broke into the camp before the big Super Bowl in Minneapolis. He's thinking about how the security failed to have all of a sudden LaFalce shows up. So, Congressman LaFalce, you just listened to Dave Flynn saying his entire career at Phillips Lytle is based on the fact of Superfund. You just heard from Paul Newrider, president of Krog, saying all of his development, the largest probably brownfield developer in New York State, that there probably was a direct connect to the Superfund legislation, which you implemented. We saw the picture with you with President Carter. What's your reaction to having heard all this?
The reaction I have about more and more things in life, that's how little I know. I little understood the tremendous impact of Superfund, and I understand it a little bit better today, having listened to both David and Paul.
David, you get a sense, because your Phillips Lytle career sort of emanates around brownfields, and you write extensively in trade publications, et cetera. Do you see that direct connect? I know that was part of your program, but Superfund, Love Canal, Superfund reaction to the Love Canal Superfund, which sort of worked its way in a direct line?
Definitely. Particularly in Western New York, everyone in the practice understands the relationship between Love Canal and Superfund, and it's almost pathetic. But if I'm at a meeting somewhere out of town and regarding Superfund, I'm looked at with some sort of reverence because Love Canal is almost a historic landmark in the Superfund and environmental practice area. And if you can say, and I did for just a little bit, that you worked on Love Canal, that's almost as intriguing as saying you helped paint the Sistine Chapel.
Congressman?
Well, I'm thinking back now, 20 years after Superfund, in the year 2000, at this time, Lois Gibbs had formed a nationwide environmental group. I forgot the exact name of it. But they decided to have a 20th year celebration of Superfund and give awards to 4 individuals. And one of them was Doug Kossel, who was administrator of the EPA under Carter, and another was Vice President Al Gore, because he was Vice President at the time. Another one was me. But I happened to sit next to the fourth honoree, or first honoree, Jane Fonda. And I had never been a fan of Jane Fonda, especially when I was in the Army during the Vietnam era. But I fell in love with her that evening. Oh my God, she was so warm and just a great human being. And particularly, I remember when her adult daughter came up to her and bent over and was talking with her, and then Jane started putting her hands through her daughter's hair. And I said to Jane after her daughter had left, I says, how wonderful that you have such a great relationship with your daughter. And she looked at me, she was sad, she says, so am I, John, but unfortunately, it was not always so. And so it was that little personal vignette that, made Jane Fonda, near and dear to me.
So that's another legacy of Love Canal. I get it. Everybody taking notes?
She was married at one time to Tom Hayden, and Tom came into my office during the process of getting Superfund enacted. He was a state legislator in the state of California at the time, and very active on environmental issues.
Paul, you're doing a project on Chautauqua Lake. Is there a connect to what you showed a couple of slides here in Watkins Glen and otherwise? Is there a connect to the brownfields in that site?
Well, that's a great question. Technically, no, there's not a connection to the brownfields or to the brownfield cleanup program, but not unlike what we did in Clayton in the Thousand Islands. I tout those as brownfield sites because they are formerly used sites. When we got to the Thousand Islands, when I first went up there in 2009, I met the local folks from the municipality. They said to me, they said a little taller in their chair, we are so proud of the fact that we took this former industrial site. It was the home of the Frink snowplow manufacturer. They invented the steel snowplow in Jefferson County. And they were very proud of the fact that they had cleaned up the site, and they had borrowed the money from the county, who in turn were getting funding from the state, but had to pay that back. And the way they were going to pay that back is by selling their 8 acres for $2.1 million to us. And we said, well, that was a great thing that you did to clean that site up, but it was probably the biggest mistake you made as well, because if you hadn't, the site would have been eligible for the brownfield cleanup program. You wouldn't be beholding to the county and in turn the state for that funding. So in Celeron, similarly, the property is not a virgin site. It was used. It had the amusement park. There's concrete in the ground, and we do have to face those challenges. Fortunately, we don't have the same kind of environmental challenges. There are more physical challenges there, but not unlike what we encounter on other previously used properties.
Sure. Congressman?
Yeah, just one comment. When David was talking about lenders' liability under Superfund, that clearly was an unintended consequence of Superfund, and it was because I think it was a Third Circuit decision which extended the liability to lenders, even if they had no contact other than making the loan to the owner of the property. And a small businessman in my district came into me and complained about this, and I said, well, this is an absurdity. So I checked it out with the bank, and there was this circuit decision. Pretty sure it was Third Circuit. I said, oh my God, this is a real serious problem. So I called up the president of the American Bankers Association, Ed Yingling at the time, and I says, there's a serious problem that the bankers are going to be having, and we're going to have a credit crunch on our hands. They're not going to make any loans. And he says, I haven't heard of this, John. He says, But if you say there's a problem, he says, I think there is a problem. He says, I'll get on it right away. I also worked with a local attorney, and maybe a friend of yours from the Hodson Russ firm, Harry Myers. Sure. Yeah, he was terrific to work with in trying to shape remedial legislation to deal with that problem. And I don't know that we came up with the best solution, but we came up with best effort we could make at the time.
So what's the current law on that, on lender liability?
Well, there's got to be a set of circumstances, and I think that Dave explained it fairly well. You know, the lender would have to have de facto, if not de jure, control, or at least some important role in the determination of what's going on the property. But Dave, we could,
No, that's correct. It's the level of involvement in decision-making and control of expenditures that really is.
So if you're a
determinant.
receiver, if you go in and apply for it to become a receiver, does that naturally put you in that position as a decision maker?
It can, and oftentimes, you know, we're retained in that situation because the receiver, where it can become personal liability for the receiver, wants to make sure that they don't get too involved. And oftentimes you'll see, and again, it's another unintended consequence, estates and receivers, they'll just abandon properties because they don't want to touch them. They don't want to be involved in investigation or finding a problem, but not in a position to spend the money to address it. So often you will see these properties just abandoned by an estate or in a bankruptcy.
Dave, refresh my recollection, because I do not remember I do not believe that strict liability applies on lender's liability.
That, generally, you're correct.
It's got to be shown of negligence. Yeah.
Generally, that's the case.
Which differs markedly from
the typical standard.
the typical standard, yes.
Lots of news coming out of the current administration about the EPA and its survival and the economic impact of it. And the questioner asks, what will be the impact on your work here, both?
I have a real sense of deja vu. You know, the appointment of individuals as Secretary of Labor who opposes everything that the previous Secretary of Labor wanted to do, opposes the concept of a minimum wage, who had the most difficulty with relations with employees. And the appointment of someone to head up the EPA who wants to withdraw the United States from the Paris Accords on climate change, who does not want to carry on the environmental fights that we fought. I'm very, very concerned about that. But it does remind me a bit of some of the appointees, and I've had some of them, of President Reagan, like Dave Stockman and Ann Gorsuch.
So, David, Paul, do you have a sense of kind of crystal ball where this is going? I know that's just about what it is, but from your tea leaves, you get a sense of how the federal potential changes could impact your practices and business practices?
As I mentioned in my earlier comments, oftentimes businesses and people in New York are critical of New York because we oftentimes hold ourselves to a higher standard, sometimes to our detriment. And I think a reaction that we're likely to see at the state level is stepping into the breach on the federal level. So to the extent things are unwound, defunded, whatever they may be at the federal level, we're, in my view, likely to see the state trying to step in and make up that difference or that gap. And I think that's unfortunate because it leads people to perceive us as being less competitive and that we're overkill compared to the rest of the country. And I'm concerned that that's maybe what happens.
John?
Yeah. One thing I'm concerned about, and then I'll say a couple of positive things. I was very concerned that there was a coalition of both Democrats and Republicans, not too many Republicans, but Trump was one of them, opposed to the TPP, the Trans-Pacific Partnership. You know, the groups that didn't want it were the labor unions And because of that, the Democrats, et cetera, other than Obama, the ones who opposed it most strongly were China. China hated the concept of the United States participation in TPP. And I think it was a huge mistake for us to withdraw from that. And China is going into the breach right now, and China is well on its way to establishing trading agreements with all the countries in the Pacific region. But I am encouraged by President Trump's ability to do a 180-degree about-face and a reversal, and just do it and say, okay, it's done. And I'll point to two examples because I was very involved in both of them. I have a picture up in my office of President George W. Bush signing a reauthorization of the Ex-Im Bank that I was the chief author of, along with Eduardo Aguirre, who was the president of the Ex-Im Bank at the time. And President Trump strongly opposed that during the course of the campaign, and then recently reversed course and said, oh, it's really a good thing now that he's in office. The same thing is true with respect to the Chinese manipulation of the currency. He said, oh, they are the world's worst currency manipulator. Well, I was involved in that issue, and I authored a bill that was enacted into law, which called for the Treasury Department to make reports every 6 months on the largest trading partners we have in the world and what they were doing with respect to their currency and whether or not any type of manipulation was taking place. So every 6 months, that report comes out. And I was so worried that Trump was going to order his Treasury Department to say China is a manipulator. Well, the fact of the matter is, since 2005, they've been doing their very best to make sure that their currency is not depreciated, because that would bring about great instability. Larry Summers, the Secretary of the Treasury under President Bill Clinton, and one of the leading economists in the world, recently wrote an op-ed piece praising the Chinese for what they were doing. And I was pleased to see that President Trump, after his dinner in Mar-a-Lago, said, well, they're not manipulating anymore, so we're not going to call them currency manipulators anymore. So those are some bright spots on the horizon.
Question for Paul. You get this clearance from the state DEC, I suspect, regarding the project you said you would do. That you get the clearance with a whole bunch of caveats on it. The questioner asked, what's the extent of the government oversight at such a remediation site? When you get the letter, they come into annual audits? You have to expose yourself?
Yeah, so before we complete the work, there's really 3 phases of this. There's the development of the plan to remediate the property, which goes through investigation, looking at different alternatives to the remediation, consistent with the proposed reuse of the site. Developing a remedial action work plan, which is like the specification for the work that's going to be performed. All of those get reviewed and approved before the work commences, which, by the way, is a subtle change to the 2015 law, which says they really want, the DEC wants to approve that remedial action work plan before any work is performed. Then during the course of the remediation, the DEC is constantly overviewing, visiting the site, verifying that the work is being done consistent with the approved remedial action work plan. At the end of the work, the environmental engineer puts together a final engineering report, and that documents that all of the work, again, was performed in accordance with that remedial action work plan, and that leads to the certificate of completion. Subsequently, each year, we file a report on that site that verifies that the site is continuing to be in compliance with what was done, with the laws and with the cleanup plan that was implemented, as well as complying with the environmental easement that goes in place during the course of the remediation and prior to the COC that defines exactly how soil or groundwater needs to be managed long-term, and that runs with the land as part of a permanent easement.
I see Judge Martocci's looking at his watch. I follow everything that Judge Martocci does, because he knows at 12:40 lights, we get our time in, life is good, and we got 3 minutes. And I have one question I never got around to asking you, Congressman LaFalce. When you said last night, ask me about Justice Sandra Day O'Connor, and I'll give you a response. So, do you remember the story?
Well, a couple of stories, but I was at the physician's office in the United States Capitol, and the members of the Supreme Court always use that doctor's office too. So I was there when she was there, and I said, Justice O'Connor, I said, we'd love to have you at my college, Canisius College, in order to give a speech. We have had a number of other Supreme Court justices. And she said, well, how far is that from Chautauqua? She loved the Chautauqua Institute. And, well, another story, too. There was a young man who interned at the Phillips Lytle firm, your firm. And I thought very, very highly of this young man. And he wanted to become a clerk for Justice Scalia. Now, I had developed a very, very close relationship with Justice Scalia, primarily over our love of food and wine, the same kind of food and wine. And so we used to go out with some frequency. So I wrote, Dear Nino, regarding this individual. I'll tell you his name in a second. I said, you have to consider this young man for a clerkship. I said, number one, he's Italian-American. I said, number two, he's Catholic. Number three, he came in first in his class at a Jesuit college, Canisius College. Number four, he came in first in his class at Notre Dame Law School. Number five, he was editor-in-chief of the Notre Dame Law Review. Number whatever the number is next, and you're the only Supreme Court justice he wants to clerk for. His secretary called him up and said, John, you've hit every one of his buttons, you know. So he did retain Anthony Belia as his law clerk. In the meantime, Sandra Day O'Connor had a law clerk, Trish. I've forgotten Trish's maiden name, but her last name now is Belia. So Justice O'Connor's law clerk and Justice Scalia's law clerk from the Phillips Lytle firm that you may be familiar with became one.
You know, having the congressman say something nice about Phillips Lytle is a great way to end, don't you think? Ladies and gentlemen, please thank David, Congressman LaFalce, and Paul Noretta. Be sure. Mary Keating is right over there. For the lawyers, make sure you give them that. And with that, we thank you very much. Downstairs is free food, free books, free interview, and a chance to chat with these folks. Thank you very much.